Hi everyone, this is Sulbha Rai Sankhla, and we are here together to do a webinar on estate planning 101 for busy parents. Thank you for your interest, and let's proceed with the presentation. And you're free to ask questions at the end of the presentation. So we'll start with information about me. I'm a dual qualified attorney from India. I have 18 years of experience in law, and we have been helping families doing estate plan for more than 3 years now. Uh, we also specialize in immigration, real estate, business law. I'm a mother, I'm an immigrant, and I can very well connect with most day-to-day issues we face in our lives. With that, let's start with our seminar. So what is estate planning? I think there's a misnomer within people where they think that estate planning is only for the rich. Like, if you have a lot of money, then you need to plan. But if you don't have a lot of money, then, well, not required. But that's completely incorrect. Even if you have something more than $100,000 in US, you need to have a will for it to go to your loved ones. So a will is a very basic requirement, and a will is a building block for estate planning. So estate planning means making decisions for your loved ones when you're gone, right? So those decision making can be in the form of a will, maybe a little more advanced for a trust. If you have minor kids, we need guardianship. How would the medical care would be done if somebody is incapacitated? What happens to inheritance? What happens if the families are overseas? So any and all of these decisions are estate planning. So as we talked about what is estate planning, let's also talk about why estate planning, right? Estate planning is there for protecting your spouse, right, from any legal challenges they might have from your assets, protecting your children, and protecting your legacy for what you build during your lifetime for your family. Estate planning is also required to avoid court or to give a fair share to your family without a court deciding what should go to whom, right? And we want our wishes to be followed. If we have written our will or our trust in a certain way, we would want that our wishes be transmitted to our family the way we want it, and it's not dictated by the court. So let's quickly discuss how a will works. So in Washington state, when you create a will, nobody is checking what you're writing. So you're basically creating a will of what you want to write. And there are two witnesses who are attesting that you wrote that in front of them or you signed on it in front of them. And then there is a notary attesting that the three people who are signing is the correct person who are signing, right? So they're just identifying you as the signers. So it's a legal document which will only be used when you pass away. And because no validation is done for that will during your lifetime, now the validation needs to be done when you pass away. And who does the validation? Court, right? So we need to go through a court process, which is called probate. And the probate can take anywhere from 6 months to 2 years, or even more, depending on how complex your estate is and how quickly your family can come in to fight for that inheritance. That process needs to be completed. Now, the good thing about the will is that you can nominate guardians for your minor children in the will. And it's at least one building block. At least you have something in place so that your wishes can be transmitted. Now, a little more advanced, how a trust works. So you must have heard a lot about revocable living trust and why it is important. But let's quickly go over what a trust is. So a trust is a revocable living trust is an intention to create a trust. And here you are attesting and verifying all your assets during your lifetime. So imagine that you created a security lockbox And in that lockbox, you put all your important things. So your house, you deed it to the trust, your bank accounts, your 401ks, your life insurance, your investments, everything, the primary beneficiary, you nominate the trust during your lifetime. Now, because you did it during your lifetime, court is not required. So at the very get-go, you saved yourself 6 months to 2 years of court processing time. Also, I mean, because you created a trust, the assets can be distributed immediately or gradually, however you decide, because trust also allows you to do tax planning. So let's just do a quick comparison of will versus trust, right? So why will? It's simple, right? As I said, you can write it, you can have two people witness it, a you know, notarize that you were the three people who were present and who signed it, and the the document is made. But you have to go through the court process. Now, the trust, on the other hand, is complex. We do a lot of documentation beforehand. We are doing all of this validation and transferring and naming guardians during your lifetime. So it's more complex, but it simplifies everything for later. So there are no surprises. There are no unknowns in this, right? In a will, because you go through the court proceeding, it becomes public knowledge, right? Anything which goes to the court is public documents. So, who passed away, who got what is the dollar amount of each asset, everything becomes public information. Whereas the trust is a private document. All the decisions you made are protected and private. Now, anything which you forgot to write in the will still goes to the court, right? And the court will then decide how those assets are going to be distributed. Whereas in trust, tax planning is an option. As we talked earlier, it takes 6 months to 2 years or even longer for a will to process. But a trust, on the other side, takes 2 to 6 months to process. The will, immediate disposition of assets needs to happen. That means if the will is finalized, the court accepts it, all the assets transfers to everybody immediately at that point. More or the less times, we want the trust to keep assets protected, especially in the case of minor children, which you get through trust, which is not an option available in will. And also, at minimum, you should have a will. You should have a will to have your assets distributed the way you want. You would need to, or it's better to have a trust if you have real estate, if you have minor children, or if you have overseas ties, or if you have all of these, right? So you want to make things simple for your extended family or your family overseas because they don't understand the US assets at all. Let's quickly talk about the estate taxes. So there are different estate taxes if you are a visa holder, if you are a green card holder versus you are a citizen. So right now, if you're a visa holder, your estate tax exemption at federal level is $60,000. And if you are a US citizen, then you currently have $13.6 million of federal tax exemption. Now, when I say federal, and then I'm going to talk about Washington, what is different is both of them applies, right? And it's just that Washington has a lower threshold. So if you have assets worth 2.2 million or above, then the Washington estate tax will apply. And then if you have assets above 13.6 million, then the federal tax would also apply. On the reverse side, if you are a visa holder, then federal tax will apply if you have assets above $60,000. And then if those assets are above 2.2 million, then the Washington state tax would apply as well. Now, there are more issues where there is no dual tax treaty. Now, India has dual tax treaty, so this might not apply, but there are certain countries who do not have dual tax treaties. And now, if assets are going to your overseas families or overseas dependents, then we also have to worry about these taxation issues, which the will cannot assess or, provide for. So what happens if no plan? Like after all this discussion, I think it's very clear you will lose your assets. There's no protection for kids. There's no decision making, and definitely there's no privacy because anytime you go through the court, all your information becomes public talk, public knowledge, and public information. So let's look at first scenario. Okay. So what happens if there's a visa holder? So let's say there's a person named Raj, he's on H-1B visa. He works in a tech company in Bellevue. He's the sole bread earner. He has a wife named Priya and two minor children. Heaven forbid, he meets an accident, and now his dependent spouse not only has this fear of losing her visa status, but also all the assets can be lost, right? Because one, to get those assets, she should be able to stay in US longer to contest it, right? So that's an immigration issue in itself. But also all those assets are locked in probate. So till the time she can't go to the court and contest it and complete the process, she does not have access to those assets which her husband left for her family, for her children. What could have helped? If they had an estate plan, then definitely they could have made these things easier because with no will, court decides, right? With no trust, assets go through the court process. And there is a risk that if for any reason some assets were unknown to the spouse, and if those assets were not able to be found by the court, then those will go to Washington state unclaimed property. What if the spouse passed away and at the same time you know the surviving spouse is incapacitated, maybe a car accident? Now the children will go to child support because they did not have any temporary guardians assigned, and there is no automatic guardianship between blood relatives in US. And as we said, any unclaimed property just is gone. And most of the times, our overseas families don't even know about our assets. So the chances of that happening is more than often very pertinent. Let's take another example. What if there's a family of US citizens, right? So we are not even thinking about immigration issues, but we are talking about, okay, what happens? They are citizens, nothing, no other problem going on. They're two very healthy individuals, Sarah and Michael. They have two young kids. They have family in a different state. They thought, they're healthy, nothing is going to go wrong. But unfortunately, they met a car accident and they're both incapacitated. What happens to their child? Now, the scenarios are different, right? We talked about the visa holder, we're talking about a US citizen, but the process is still the same. So it doesn't matter if your children are foreign citizens. If they are in US, the child protection services still have the right to take care of them. They still have the right to put them in foster care system till the time they can reach the appropriate consulate to then reach the appropriate country for extradition. The extradition will take its own, due course. But during that time, your kids are not with the family you think can protect your kids. They are with foster care system on parents, which are determined by the government. So let's talk about a final scenario. What if, something happened in the first scenario where they're a visa holder and it's a family of four and all four did not survive. And now the only beneficiary is their family in India, their parents and their siblings. Their parents and siblings don't know about the assets they own, right? So first, they should have a visa and they should have knowledge of where those assets are. And then they need to come here to US, contest it in the court, prove that they have the right to inherit those assets before they can, get anything. Now, what happens if it's an incomplete process or if the process is not initiated? So if there is no process initiated within 16 to 18 months, generally the banks will notify Washington state of unclaimed property. And because the banks or the institutions do not want to be liable, they will transfer all that money to Washington state unclaimed property. Right now, the Washington state unclaimed property is reaching $2 billion. So it's not a misnomer. It's reality that there's so many people who did not inform or who did not provide for this plan and have lost all their lifetime earning to the state. Let's quickly talk about why guardianship and emergency planning is important, right? As we talked about, two scenarios. So, if the parents are temporarily incapacitated, we still need guardianship to allow somebody to have temporary hold over the child. So when we say temporary hold, say the parents are in hospital for 4 days, somebody needs to take children and take custody of them. And if they need to go to hospital, those people need power of attorney to do that. Now that's temporary guardianship. Washington state allows you up to 60 days of temporary guardianship that can be assigned by you. There is no court order or no court processing required. So that is the minimum thing you should do. Now, the other important thing is to have healthcare directive and to have financial power of attorney for incapacity. Because just think of a scenario: you're in a hospital and there's nobody who can pay those bills. And you're in a hospital and you need a surgery, and there's nobody who can give consent. In both scenarios, there is a substantial risk of, not getting proper medical care. So, to avoid that situation, it is really important that you have a healthcare power of attorney and you have a financial power of attorney for incapacity when you cannot make decisions assigned to people you trust. Let's quickly talk about naming guardians, right? So, why naming guardians is important, as we've talked through our slides, that if you don't name anybody, the government decides for you, right? Temporary guardians are such a simple process. It's a legal document. It's just like writing an affidavit and saying, I authorize these four families in this order to be my child's temporary guardian in case we are not available. That you can do. Now, what happens if both of you are not there, like husband and wife, both are not there, and now the children are minor, and you want permanent guardians to be appointed? You need to create a list of people who you would like to nominate as permanent guardians, right? And then the court will look at that list and will assign somebody. Permanent guardians cannot be appointed by you. There is a court process which is required. And most of the times, it's a challenge for non citizen relatives if they are not nominated correctly to be able to take the custody of the child. So it's very important that you think about it and you have these nominations completed during your lifetime so that there is no issue in taking care of your children once you're gone. So let's conclude this. Okay. So now we're just trying to see, okay, what is the basic requirement? What do I need to do? Well, create a will. Create a will, naming guardians and outlining how your assets are going to be distributed. A little more enthusiastic, better protect your family? Well, then you do a revocable living trust because it avoids the whole court process. It assigns your assets during your lifetime. You have that satisfaction that you know who is going to get what at what time. You can do tax planning. You can say, hey, I want to provide for my children even when I'm gone till the age of 30, you can create a trust and do a distribution plan for them, which will distribute those assets over ages and stages. What is The next important thing, you do your power of attorney and emergency documents so that in case you are incapacitated and somebody needs to make financial and medical decisions for you, they have that document ready to use. And the final recommendation is that you should always review your plans. If you created a will 5 years ago, it's a good time to review it. Things have changed. If you created a trust today, it would be really great that you keep reviewing it so that not only you are looking at all the assets you have, how your family circumstances have changed, how your friends and family you trust have moved, and now you need to replace with somebody responsible. All those decisions always need to be airtight so that your family is protected in time of need. If there are no questions, I'll wrap this quick presentation today. Thank you for joining us. Feel free to reach out. We have our office in Bellevue. We also work virtually. Our website is www.nexuslaw.us, or you can email us at info@nexuslaw.us, and our phone number is 206-579-7890. Hope to see you in the future. Thank you.